Good afternoon, everyone, and welcome to the webinar, Safeguarding Victim Privacy, a Plan of Action for Prosecutors. My name is Emily Thrush, and I'm the Project Coordinator at AEquitas, the Prosecutors Resource on Violence Against Women, and I will be moderating today's webinar. This webinar will identify categories of confidential and or privileged victim information and records, discuss threshold requirements for defense attempts to obtain such information or for in-camera review of records, and suggest pretrial and trial strategies that support the protection of victim privacy, including collaboration with allied professionals to safeguard private information. Before we begin the substantive portion of our program, I will provide a brief overview of our iLink webinar service. You can listen to this webinar either via computer or conference call. For the best use of iLink, I strongly recommend calling in from a landline to the conference line 530-881-1212 with the passcode 202-731-738#, and that number is in the upper left-hand portion of your screen. If you're using a mobile phone, please do not use the speaker option. You can listen with an earpiece if necessary. All call-in participants will be automatically muted throughout the webinar, and today's webinar is being recorded for later viewing. To connect to internet audio, please click the Connect button on your start screen. If you use this audio option, please do not also call to the webinar. Only do so if you experience difficulty with your internet audio. If you have any technical issues, you can use the iLink hand raiser indicator, which is located on the toolbar in the top left-hand portion of your screen above the presenter's photo and to the right of the conference call number. Or you can contact iLink directly at 800-799-4510. Throughout the presentation, if you're unclear about anything or you'd like clarification, you can chat with me using the private chat feature. Any questions you might have, which the chat portion is on the left-hand part of your screen below the attendee list. If you have questions for the presenters, I will share those questions with the presenters anonymously so they can be addressed during the webinar. Today's webinar is hosted by AEquitas, the Prosecutors Resource on Violence Against Women, through the funding from the U.S. Department of Justice, Office on Violence Against Women. Written materials, including a copy of the PowerPoint presentation and both presenters' biographies, will be emailed to you after the presentation. Today's webinar is also being recorded for later viewing. AEquitas' mission is to improve the quality of justice in sexual violence, intimate partner violence, stalking, and human trafficking cases by developing, evaluating, and refining prosecution practices that increase victim safety and offender accountability. AEquitas provides prosecutors with the support, training, mentorship, and resources necessary to objectively evaluate and constantly re-examine and refine their approach to justice. AEquitas staff conduct legal research, provide 24/7 case consultation, host specialized or state-specific training events and webinars, provide individual experts to jurisdictions and organizations, and we publish articles, monographs, and other resources on topics relevant to the prosecution of violence against women. The National Crime Victim Law Institute, or NCVLI, is a nonprofit legal education and advocacy organization that pairs crime victims with free attorneys who fight to secure their rights through their national network of legal clinics and the National Alliance of Victims' Rights Attorneys. They train nationwide on the meaning, scope, and enforceability of victims' rights through practical skills courses, online webinars, and teleconferences. And they work with partners nationwide to secure the next wave of victims' rights legislation that guarantees victims' substantive rights and procedural mechanisms to secure those rights. They provide model legislation and they testify when called upon. Today's presenters are Viktoria Christiansen, the attorney advisor here at AEquitas, and Meg Garvin, the executive director of NCVLI. Prior to joining AEquitas, Vicki served as a deputy attorney general and special assistant to 2 New Jersey attorneys general. She specialized in human trafficking, and while she was an assistant district attorney in Philadelphia before that, she focused on the prosecution of cases involving sexual assault, intimate partner violence, and child sexual and physical abuse. Meg Garvin teaches victim law and litigates nationwide, in addition to her responsibilities as the executive director at NCVLI. The full biographies for Meg and Vicki will be emailed to you following the webinar, along with a PDF of today's presentation. I would now like to turn the floor over to Vicki and Meg for the substantive portion of today's presentation.
First, on behalf of AEquitas, I want to thank Meg Garvin and NCVLI for collaborating with us on this webinar. We at AEquitas regularly consult with Meg on privacy issues, on other issues, and this webinar is a joint collaboration and is really about what victim privacy can entail in terms of the criminal justice process, including information and records that may be confidential or privileged, why privacy and its protections matter, and how you as the prosecutor can protect it. And so really when we're thinking about why this matters, let's look back and think about what our legislatures, our courts have done over time. And laws have really evolved over time to protect communications with professionals who provide support to various persons so that those persons, those patients, those survivors can lead healthier, happier, and less conflicted lives. The privileges associated with these professionals provide really a protective veil so that patients, clients, and survivors can speak truthfully about personal and often extremely traumatic details to trusted professionals without having to fear that their most personal thoughts will then be revealed. So how you can protect it in many ways is about understanding the legal privileges associated with these records and associated with the defense burdens and defense attempts to obtain confidential records. So during the next hour, we'll discuss some pre-trial and trial strategies you can utilize to prevent the defense subpoena of these records and do so when such prevention is legally and ethically appropriate. And then strategies for prosecutors to employ when records or portions of the records are then ruled admissible by a judge. And we always start with framing everything that we do based on the concept of justice. And this is a quote from Justice Cardozo. It's a reminder that historically the court has supported fairness for the victim. That includes a victim's right to be free from harassment, free from humiliation, and a victim's pursuit of justice is in many ways possible specifically due to confidentiality laws, right? For many of the reasons that we discussed in the previous slide. It's the foundation upon which victims can rebuild trust, can rebuild empowerment, and can rebuild autonomy, and it allows them to participate in the criminal justice system. And interestingly, when we're talking about the ultimate responsibility of the prosecutor and the importance of advocating for victim rights but doing the right thing, 1 year after this case, in 1935, the United States Supreme Court decided U.S. v. Berger and reminded all of us and told us that it is as much the duty of the prosecutor to refrain from improper methods as it is to use every legitimate means to bring about a just conviction, a just result. And so we want to do this when we're thinking about justice for those whom we have charged, and certainly justice for the survivors of the crimes that we are prosecuting. So in these first two slides, we'll discuss the difference between privacy, confidentiality, and privilege, and then we'll discuss specific privileges and protection of records and information. So first, let's talk about the right of privacy, which is the right of a person to be free from unwarranted public scrutiny or exposure. Legal scholars have noted that the concept of privacy protects very different rights, and that's one of the many reasons that some of these rights can be confusing to us as lawyers. And the use of that single term, that term privacy, has caused a lot of confusion. So there's a constitutional scholar that many of us are aware of. He's now the dean of UC Irvine Law School, but Erwin Chemerinsky. He published an article in 2006 in which he noted that privacy is really about three rights. First, it's about an individual's right to be free from government intrusion, and that's usually a text of Fourth Amendment. Second, it's about a person's right to make certain crucial personal decisions, right, a constitutional protection for autonomy. And third, it's about informational privacy, prohibiting the non-consensual disclosure of any information that has been retrieved from a protective record. Think of confidentiality as the broad application of privacy laws used to create a duty a duty to protect the victim's information and safety. Confidentiality is an ethical and a legal duty that a professional owes to a victim or client or a patient to keep certain communications and information private, safe. Those are communications that are made within the protected professional relationship, and they can also be communications made during relationships such as a husband and wife. Think about an attorney-client communication, a priest-penitent communication, and those are legally protected from forced disclosure. So what's the difference between confidentiality and privilege? One example can be found when we talk about the attorney-client relationship, where confidentiality is the lawyer's ever-present duty not to disclose information related to the representation of the client. But the privilege is asserted when there's a legal demand for communications about the client or client-related information. So the client holds the privilege, which permits the client to refuse to disclose confidential communications between him or herself and the attorney, and it also prevents any other person, including the attorney, from disclosing the confidential communications. Privilege is the legal right that gives both the sharer and the holder of information special protection to refuse to disclose privileged communications within the confines of certain relationships. So while confidentiality is a duty, a privilege is a legal right that gives both the sharer and the holder that special protection so they can refuse to disclose those privileged communications. So privilege will override, in many cases, a witness's duty to disclose matters, whether at a trial or whether they are requested to disclose at a deposition. So the holder and the owner of the privilege is the client, and the professional, even under court subpoena, can't divulge protected privileged communications unless, and we'll discuss these today, the client, patient, survivor gives express permission, the client, patient, survivor waives the privilege, or there's a recognized exception to the privilege. And there could be other public policy exceptions, such as a duty to warn a third party of specified harm.
So this is Meg, just so folks know, I know my picture pops up on there. Thanks, Vicki, and thanks, AEquitas. I'm going to transition here and have us talk, building on what Vicki was just talking about, kind of why is confidentiality important, just a little deeper, and why is privacy important a little deeper, and how that all plays with privilege too. And I just want to flag, this is a really great webinar. In many ways, it's something that is novel in that a prosecution-based agency is talking to, I'm a lawyer for victims. Like this partnership of how do we together make sure justice is done, but that we protect survivor privacy in the process is really, really wonderful. So I'm really grateful to AEquitas for all of their work on this really important issue. So with regard to confidentiality, and privacy, I just want us to, and this whole hour that we're together, really remember some of the foundational aspects of this and why it's so important. It is confidentiality, what we know from now study after study after study, is that it is absolutely critical that survivors feel and actually have confidential and private settings in which to discuss their victimization. It is important so that they can actually tell their story and in a way that is safe and not vulnerable beyond the general vulnerability that comes from disclosing personal information, but so that it's not vulnerable to subsequent attack, because we know from studies on the neurobiology of trauma, from studies on engagement with the justice system, that this is the foundation both for recovery from trauma symptomology and for engagement in the system. So it's utterly critical that there is confidentiality and that survivors know they have it so that they can feel comfortable accessing resources in the aftermath of their victimization. And there's this wonderful quote that I would imagine most of us use, but we still at NCBLI still put it in most of our trainings. It is this idea that privacy, and Vicki really laid the foundation for the difference between privacy, confidentiality, and privilege. This quote is really an overarching quote about how all of those things go to fundamentally protect the notion of privacy. And this quote is, privacy is like oxygen. It's a pervasive, consistent need at every step of recovery for survivors, for some survivors at least. Within the context of the legal system, if a victim is without privacy, all other remedies are moot. That might sound like hyperbole. When you're sitting with a survivor, you know it's true. But when you step away and you're thinking like a lawyer, it might sound like hyperbole, but we know from data now that it is not hyperbole. When survivors feel and actually do, in fact, lose their privacy, they will change behavior, right? So we know from studies, victims and survivors will simply not report crime if they do not feel that they can access services confidentiality under a confidential umbrella. They will not report crime such that the criminal justice system can move forward if they don't have it. So we know that they won't access services such that they can heal, and the criminal justice system can't work if they don't come forward. So two different avenues get blocked when privacy is undermined. The second is, even if they come forward, right, either just to access services or to access services and engage in criminal justice, if they come forward and then privacy is compromised, what we know from the data is the attrition rates are really high. The survivors drop out of the process because it is no longer serving their needs. So we know that happens. And so it is utterly important that we understand those two foundational moments, because it's not hyperbole to say that privacy is like oxygen. It literally is the foundation for them moving forward in their surviving, as well as the criminal justice system acting, because without them, we can't do anything. And it is really important as we do this that we understand, and you all know your obligations, but when the prosecutor gets information, so does the defense. So one of the things as a victim's attorney that I do is I talk to my survivors a lot, my clients a lot, about the pros and cons of giving certain information to the prosecutor, right? And I hope all the prosecutors on the webinar hear what I mean by that, right? It's not that I'm saying let's impede your incredibly important efforts to secure a just outcome. What I'm saying to the survivors, let's talk about what it means to turn this piece over, this part of your diary, this part of your cell phone. Let's talk about it so that you understand the ramifications. And included in those ramifications are, if you as prosecutors get it, you're going to, in all likelihood, under Brady and other discovery rules, have to turn it over because of your obligation to balance and factor and defend essentially both victims' rights and defendants' rights. You guys have, prosecutors have perhaps one of the hardest jobs as a lawyer, right? Not just in the criminal justice system, but as a lawyer writ large, because you have to protect so many people's rights. So it is incredibly important that we think about that and we understand it. And then as we shift into, as the webinar shifts into so what's protected, what are we focusing on now, we just wanted to put on the screen some visuals about understanding what all gets attacked, right? And I would guess all of you have seen subpoenas for various of these moments, right? So on the screen, you have a whole bunch of tech symbols on there, right? Those represent subpoenas for cell phones, for Google searches, for Facebook pages, Facebook messaging, Twitter accounts, education records, hospital records, counseling records, employment records, victim compensation. Applications to victim compensation are now subpoenaed pretty routinely. All of this is what happens as a survivor navigates the criminal justice system with you, the prosecutor, right? And you and I, as legal professionals, see these as these subpoenas. Sometimes we see them as crazy making, right? Like, gosh, why did the defense subpoena that? Other times, though, you and I can look at them and say, well, they're doing their job, right? Or, well, that is a piece of the case. From a survivor's perspective, all of these subpoenas, every single one of them, is a commentary that says you don't believe her or him, right? Or the system doesn't believe him or her. And my God, in order for you to believe me, I have to turn over my whole life to you, right? So these subpoenas and the other devices by which attacks on privacy happen, it is one thing for us to know how to respond to them legally. It's another thing to understand what it means as a survivor is navigating them. And I know Vicki is going to cover a little bit about survivor preparation later in the webinar, but I wanted to flag that here too, because what's on the screen is really overwhelming if you're the survivor, and every single one of those images represents something in your life that might get subpoenaed or questioned or in fact turned over sometimes with no notice to you. So I am going to embark on a couple of the specific types of, actually Vicki's going to embark on a couple of the specific types of records off the bat, and then we're going to tag team as we go through them. So I think I'm going to turn it back over to Vicki now to talk about counseling records.
Thank you, Meg. This is Vicki, and I just want to piggyback on some of the things that Meg said earlier and really flag for everybody that when these issues do arise, this is a wonderful opportunity for lawyers who are working as prosecutors and lawyers who are working in civil capacity or lawyers who are doing work like Meg does to collaborate so that we can better serve our survivors and get better results in our case. So I want to move forward when we're talking about counseling records. You know, we're talking about counseling records and a lot of other different kinds of records that could really implicate some privacy concerns, and certainly there are privacy rights attached to these. So the majority of states, if we're talking first about advocates, the majority of states now recognize a community-based advocate client privilege. So each state's laws vary with regard to who is a qualified counselor, what, if any, communications can be revealed and under what circumstances, and whether and to what extent the privilege applies in civil and or criminal cases. So the Connecticut statute that we featured on the slide covers both sexual assault and domestic violence and covers information shared between a victim of domestic violence or sexual assault and a domestic violence or sexual assault counselor in the course of that relationship and in confidence. The Pennsylvania statute mentioned for human trafficking advocates not only provides for the privilege but also details how such caseworkers can become certified and otherwise have their communications be confidential. In addition to statutory provisions, some funding sources, including grants received under the Violence Against Women Act, contain confidentiality requirements that apply to program grantees, and this is certainly true for domestic violence and sexual assault program grantees. So grantee programs and their staff would then be prohibited from sharing confidential information of victims who receive services from their agencies except in limited circumstances, including if the victim expressly consents to the disclosure of information. But I would certainly caution, just as Meg said earlier, that those disclosures are not always going to be appropriate and certainly not always going to be in the best interest of the survivor or the best interest of the case. I want to note that the statute features here cover victim witness advocates and not victim witness assistants who are employed by a prosecutor's office. And although the latter in so many ways really are victim advocates, a victim witness assistant employed by a prosecutor's office may be regarded as part of the prosecution team and thus may or may not be able to protect sensitive or private victim information. Some courts have ordered production of the victim witness assistant's notes from his or her communications with the victim. In Massachusetts, for example, prosecutors have an affirmative duty to review the victim witness advocate's notes and inquire about conversations with victims, and the information is subject to the same discovery rules and obligations as other information that is known by prosecutors. The last rule listed on this slide is Military Rule 514. That rule states that a victim has a privilege to refuse to disclose and prevent another person from disclosing confidential communication made between the victim and an advocate in a case arising under the UCMJ if that communication was made for the purpose of facilitating advice or assistance. And the privilege can be claimed by the victim or any guardian or conservator. of the victim. All 50 states recognize some form of the psychotherapist patient privilege, which encompasses communications between a patient and his or her psychiatrist, clinical psychologist, or clinical social worker. And basically, most jurisdictions' rules, including the military's, governing the psychotherapist patient privilege are similar. So Ohio's, which we featured on the slide, for example, places the confidential relations and communications between a licensed psychologist or school psychologist and client on the same level as those between a physician and a patient. And so, for example, when that was challenged, where there was a domestic violence case in Ohio where a defendant husband was convicted of assault against his wife, and at trial the court excluded the testimony of a psychologist who would have testified that the victim said that the DV charge was fabricated. The court held that the communication was privileged, and the Court of Appeals affirmed, finding that the victim was a psychologist patient and thus protected by the psychologist-patient communication privilege, even though the defendant husband had been present during the counseling session and overheard the communication. And some of this goes to also, and we'll talk about this later in the webinar, when we're talking about obtaining records that are privileged, one of the important things to consider is whether the information contained therein is available from another source. The federal rule that's listed here, I just want to note, contains all privileges comprehensively. So if you're practicing and you are governed by federal law, you're going to look to 501 for all of your privileges. And finally, for the military, while the state rules are generally similar to the military rule of evidence 513, there are two notable differences that exist for the military rule. And if anybody wants more information on this specifically, we are happy to follow up with you after the webinar. So we've received a lot of technical assistance requests, and we've talked about this with Meg quite a bit over time, regarding both general counseling and psychological records being subpoenaed by the defense, as well as records that are protected by a specific statute covering communications between an advocate and his or her client being subpoenaed by the defense. And the psychiatrist-patient privilege protects as we talked about, the communication between the patient and the psychiatrist made during the relationship involving diagnosis and treatment. And so depending on the language of the particular state statute, the privilege, again, can encompass psychologists, therapists, counselors, and you just have to be very, very careful to look closely at the professional involved and what your state statute covers. Meg?
Great. I am going to cover just a few additional records. I'm going to start with medical records. And I think this is one that most folks are generally familiar with, but some key points here, right? The physician-patient privilege excludes confidential communication that a patient makes to a physician for the purpose of diagnosis and treatment. That is a key component in all of this, in whether it's the mental health moments or the physical health moments. The intersection of purpose of diagnosis and treatment is really important. But that's covered by privilege, right? So you can, as Vicki has talked about the difference between what we can do with privilege and confidentiality. There are, of course, waivers of all of these privileges. In the medical context, the waivers come very often when, right, a survivor is going to waive access to her privileged medical records with regard to the incident itself, right? And that can also happen when a subpoena issues for the specific incident records, right? Those are really important both to know they can happen, but to understand it's a waiver when the victim waives there, right? And to make sure that the survivors we work with are not executing general waivers. I think the nonprofit sector and victim services folks who work in the non-system setting, they really focus on narrow waivers a lot. But I think as prosecutors, you also need to really be thinking through the idea of narrow waivers so that the defense doesn't like find in a waiver something that gets them to an incident in the medical records that happened 1 week before, 1 day before, right? So the waiver of privilege, medical privilege, for purposes of getting you, law enforcement and prosecutors, information about the incident itself should be incredibly narrow, but that does happen. And of course, with regard to many of these privileges, it is true of medical privilege as well, that in many jurisdictions, there are exceptions to the privilege for purposes of mandatory reporting. And I'll just note here that AEquitas has a compilation of the reporting requirements for medical practitioners, so I would direct folks to access that when you can, to reach out to them for technical assistance. Other records that are held and that sometimes actually have some mental health moments in them, some medical health moments in them, are kind of youth and family or DHS type records. And what you have on the screen in front of you is the Oregon example about confidentiality over certain records that are held by the Division of Youth and Family Records, which in Oregon is essentially Child Services, right, or DHS. And it's really interesting to look at these confidentiality provisions in the jurisdiction in which you're working in to see the scope of them, but then put that confidentiality provision up against other obligations and legal rights that exist. So for instance, in Oregon, in a now relatively older case, a 1987 case, State v. Warren, the defendant was seeking access to records that the Children's Services Division had, CSD had. And the initial reaction of prosecution was to not release those records, right, to have CSD not release the records, citing a myriad of things if you look through the briefing and the arguments on it, including some confidentiality provisions. But the court ends up vacating the conviction because it started to look at the interactions of Brady, essentially, without always naming it Brady, who has control over some of the records. And the court ended up saying that in this case, while the files were confidential, prosecution was obligated to disclose them for in-camera review. So flagging here that lots of records have confidentiality or privilege, and that your job is complex to look at also ownership of those records and control, which we're going to talk a little bit about later. And the last kind of record type that we're going to talk about are school records. So school records generally, and then college campus records slightly more specifically. School records, what you have on your screen is an example from Massachusetts. And the idea that various jurisdictions have within their states put in place specific confidentiality provisions for students, right? They actually govern students and parents. If you look at them, who really controls the confidentiality aspect of it changes based on the age of the child, right? And that age varies by jurisdiction also, whether the parent is really involved or whether it is the student who has a little more control over them. And it is incredibly important to look at these because I don't know how many of you have looked at school records in detail in recent years, but and I don't know you. I can't see all of you, and obviously the visual is not always indicative of age because that photo you have of me, I look a lot older than that now. But the school records are not what they used to be, right? Like they are not what they were when I was a kid, which was, you know, the threat of it just going into your permanent record that you missed school one day, right? School records right now are incredibly complex things, particularly when schools aren't careful, when they don't have good systems in place to segregate information. So they can sometimes have testing results in there that indicate that you're not so good at deciphering. One of the examples we saw recently, well, now it's been a few years, but there was a note in there about testing, and it said, should work with students on the difference between fiction and biography. That's a huge moment right there, right? Because it's hinting, could be used in a distorted way to say something different about the survivor, which was she doesn't know fact from fiction, right, in her own life. So really important stuff. Get to know the nuance of the law that exists over school records, both at the grade school and high school levels, and even, to be honest, kindergarten and preschool levels have some protections too. And then also campus records. Get to know those also. There are a myriad of protections over campus records now. They include FERPA. They could include HIPAA. We now know that Title IX is extending both at the college level and below to create some protections. Get to know all of them. The general rule is that campus investigation and adjudicative moments are going to be discoverable, but records from campus health centers are confidential. That sounds like a really neat distinction between them and that it should be clear, but what I will tell you is in practice, it isn't. Records from one end up in the files of the other pretty routinely, and so being very careful as you are reaching out or as you see a subpoena for these things, I would really say in these moments consult with a victim's rights lawyer whenever possible because there could be some additional protections that could happen. And in some of the campus resources that I would encourage you to access are on the screen in front of you to understand, right? FERPA, please get to know FERPA. The Gonzaga case is an incredibly important case understanding what records are which. So is the Jane Doe. Then the U.S. Department of Education has a ton of information on it. I will also say, as I already mentioned, the nuance here for victims is really significant, and campus proceedings are just coming into their own right now and understanding the rights of all the persons involved. And they are not mistakes being made, they are processes and procedures being created. And in that process and procedure creation, there are gaps right now, and those gaps are hurting survivors. So when you have a campus moment or anything that hints of a school moment, these are emerging areas of law, and I really encourage you to access the resources on the screen to know them, but also access a victim's rights lawyer to consult with. And I'm not talking about pure tort lawyers who would sue under Title IX or another action, but you could reach out to us. NCVLI has an entire publication on the intersection of privacy of victims and campus proceedings. So I encourage you just to access those as much as possible because of the complexities. Okay, we're going to transition a little bit away from specific records and raising your awareness about some of the high-level stuff of those records to how does it actually work in various jurisdictions and how can you act to safeguard victim privacy or partner to safeguard victim privacy. So to start it off, we're going to talk about the Violence Against Women Centers and Statutes. So Vicki actually already spoke about this, so I'll be really brief on it, but local crisis centers have internal and external privacy measures that protect their clients. So they're governed by VAWA, generally speaking. If they receive VAWA dollars, they have confidentiality, and they're going to be bound by those. They also will have memorandums of understanding between shared service providers that allow them to provide more holistic services to the survivors they work with and bring people under their confidentiality umbrellas. So there will be the victim advocate privilege that may exist in some jurisdictions that is implicated here. There's also going to be the VAWA protections. And the tip here is really get to know how your local crisis centers, whether it's a dual coalition, whether it's a sexual assault coalition or just a DV coalition, any emergency housing, actually spend some time outside of a case. I know that sounds crazy because you probably don't have any time outside of your cases, but if you do, spend some time getting to know how they operate, getting to understand from their perspective what governs them, because that will help you understand what you can ask for and what you can't ask for, and more importantly, how you can get between the defense asking for something and these centers so that you can be as protective as possible. This is also a moment I would strongly encourage that you all, most coalitions have a lawyer working with them, but the survivors whose records and information are actually at stake don't always have a lawyer, and they can do a lot here to quash subpoenas when they go to these agencies. So please reach out. Again, the lawyers we work with operate pro bono, so it wouldn't cost your survivors anything. So I think we're going to do feedback moment here to get some input on what is a pretty complex question. So using the feedback indicator to select yes or no, which I think is at the top, just answer this question. During trial preparation, oh, it's over on the left there, it just popped up. During trial preparation with the sexual assault survivor, she discloses past unreported abuse by a separate unrelated offender. Is that information discoverable? So let's have you guys go ahead and answer that. So you're preparing a witness, she's a survivor, and she discloses past unreported abuse by a separate unrelated offender. And I'm just going to give folks a second there to answer it. Okay. I am not going to answer it for you. I think what you see in the answers from folks is that it's a pretty complex issue, and that the question of what you're obligated to disclose versus what you have to, can disclose, pass through, and when, it's a really complex issue, right? And what we're going to spend just a few minutes on now is deconstructing it a little bit, because the defense is going to say, I have a constitutional right to get information. I have a constitutional right to confront the witnesses against me. And they are going to then say to you, give me A, everything you have, and sometimes they're going to say B, go get me stuff, right? And there's this wonderful case, I didn't include the citation in the materials, and I should have, but it talks about that the defense can't compel the prosecutor to become its porter, right, to carry its luggage for it. So understanding what you do and do not have to do is incredibly important. The discovery laws. So the starting point of all of this from a victim's rights perspective and from a victim's perspective is, could everyone's first paragraph of every motion to quash that you ever use start with this statement? The defendant has no U.S. constitutional right to pretrial discovery from a non-party, right? And then there are citations like crazy for that, right? There's no constitutional right of the defendant to get pretrial discovery from a victim. It does not exist. The right to confront and the right for compulsory process are trial rights. They do not actually attach pretrial. That is incredibly important because we know how many cases resolve pretrial. So if we can protect survivors by not letting it out because there's no constitutional right pretrial, we've done a lot for them, right? So what do defendants have? Well, they certainly have Brady and other provisions that come out of the Brady line of cases that say prosecution has to provide evidence that they have in their possession that's favorable to the defendant and it's material to guilt or punishment, right? We all know this. We know it, but sometimes we don't focus on the words, right? It has to be evidence that's favorable, right? And there's a whole line of cases talking about the weight of the word evidence. It has to be material to guilt or punishment, and you have to have it in your possession or control, right? So this is a caution for you all to know that there are times you don't want information, right? You just don't want it because you're going to have to turn it over. So what are some things you can do? You can get orders of protection in advance, and I think we talk about this a little bit later too, so I won't belabor it. But if the victim is filing, you can, A, get an order of protection over things you think the defense is going to ask for first. Do that up front if you know about it. If the defense files something asking for it, you can move to have it sealed right away or ask for a gag order. And you can do that even while you're litigating whether the defense wins on the merits to get something or not, right? So be thinking about that right from the get-go. So in terms of how you set this up, you start with defense doesn't have a constitutional right to get it. They have these narrow rights to get it in statute and rule and under Brady. Those are incredibly narrow. Put the defense to the burden, and then go to orders of protection and see what you can do. And then I would say we're going to transition and have Vicki talk in part about some of the burden and how you can actually pierce privilege to get it.
Thanks, Meg. So if we can sort of categorize privilege statutes into one of three categories. Okay, first, absolute, meaning that communications that arise out of the protected relationship are privileged, and the statutes contain no language providing for an in-camera review of the relevant record. And the exception to the privilege here would only occur if the privilege holder waived the privilege. The second would be a semi-absolute category, meaning that the communications are privileged unless voided by a public interest. And that exception would be like in a child abuse case. Or qualified, meaning that there's a limited protection for the privileged communications. And in these circumstances, a judge could hold an in-camera review of privileged records, and the judge would then apply a balancing test to determine whether the information can be released. So, for example, if we look at the psychotherapist patient privilege, we can see that 12 states fall under the category of qualified, as they have a psychotherapist patient privilege with in-camera review in the statute. And those 12 are Arizona, Kentucky, Maine, New York, North Carolina, North Dakota, Ohio, Oklahoma, Rhode Island, Tennessee, Washington, Wyoming. So in some of those states, only the judge would review the record and not the prosecutor or defense counsel. In other of those states, there's an in-camera review process that allows for the possibility of both the prosecutor and or the defense attorney to be there. So what if the defense sends a subpoena directly to an agency, a practitioner, therapist, a hospital, a clergy person, et cetera, for records, and that agency or that person calls you, the prosecutor, and says, what should I do? Should you give the agency or the person advice? And if so, what do you tell this person? And normally we see this carried out, where the defense will request records and will subpoena them on the basis that they contain potentially exculpatory evidence. And if you could all see me, you would see me doing these like kind of air quotes, And first we want to look to determine if the proper procedures were followed. So, we mentioned earlier the Military Rule of Evidence 513. Well, that rule of evidence includes procedures in the rule itself. And while most jurisdictions do require a written motion by the defendant seeking the discovery of the privilege records, few jurisdictions have actually outlined that procedure. So the military rule gives you detail, but most of the jurisdictions don't. So initially, when appropriate, we want to avoid even an in-camera review of records, right? So prosecutors should be very cautious, be aware that these requests may be a defense strategy to introduce irrelevant information to embarrass, to harass, to intimidate the victim. And we should immediately, as prosecutors, because we understand that AEquitas and NCVLI, part of the reason that we exist is because we understand the heavy caseloads under which all of you are currently laboring. And that a lot of times you're not only facing a tomorrow where you have the possibility of 3 different juries going, but you also have 5 sentencing hearings, 2 violation of probation hearings, et cetera, et cetera. So we are here to help you and to help you connect with the lawyers or the agency that doesn't have a lawyer to determine what the appropriate next steps would be. This slide really speaks to communicating with the victim and working to avoid the causing of additional trauma by the system. And by the system, I mean us, right, the prosecutors, because at a certain point, this case is going to move on. It's going to move on from the sexual assault forensic examiner. It's going to move on from that assigned detective. Those people may still be involved to some extent, particularly the detective, but the prosecutor is going to take over and is going to drive the bus. It's going to move the case through the criminal justice system and going to be the main point of contact for that survivor. And we really always want to operate with the goal of avoiding additional trauma by the system, by us. The victim expects honesty. The victim expects explanation from us. And this is an issue where you, the prosecutor, should take the time to explain the law and what is happening procedurally and what the process could look like going forward. And as Meg has said, this in-camera review itself feels like a loss to the victim. And that's why we fight so hard to ensure that the legal burdens that are required, right, the showing that the defense has to make, actually occurs. So what does the defense have to show and do in order to get to in-camera review? Generally, in order to pierce the privilege, and this again, the nuances are different in every jurisdiction. The defense is required first to file a request in writing and then to establish that the information is critical to the defense and that the defendant can't get that information in any other way. And then show that the information sought is relevant, material, and necessary. So let's consider some of the kinds of records that we discussed earlier. Advocate-client records. Generally, the defense has to establish that, again, the information is critical to the defense and it can't be obtained in any other way. And there are some very, very good cases that we can provide for you with examples in jurisdictions throughout the country. So this is an example of a case out of Michigan where the court ended up affirming the trial court's denial of an in-camera review of the victim's counseling records. And the court stated that the defendant's generalized assertion of a need to attack the credibility of the victim did not establish the threshold showing of a reasonable probability that the records contained information material to his defense. And so this court, again, upheld the denial. So our lesson from this court and what the case law generally shows us is that a generalized assertion by the defense is not going to be enough to establish the burden to get to the in-camera hearing. And here's the Arizona rule, which focuses on a reasonable cause to believe the privilege information is exculpatory. And in relation to this rule, if anybody is listening who is practicing in Arizona, we pulled actually an unreported case where the court upheld the trial court's refusal to conduct an in-camera hearing based on the defendant's argument that because the advocate wasn't an attorney, that advocate might not know what material contained in the records might be exculpatory. That was actually the defendant's argument, and the court said, sorry. Meg, I'm going to turn it back over to you.
Great. I think all of this is hammering hold defendants to their burden, right? Whoops, I went too far. Because we can and really should advocate to prevent disclosure in general and in camera specifically. And there's this great quote on your screen about an additional argument you can make essentially, which is when a pretrial discovery order will cause unwarranted damage through discovery of privileged medical records, such damage can't be cured, then you can stop things, right? So this is really important because this court is looking at burdens and it's focused on unwarranted damage, right? The only warranted damage, which we know survivors may have some, would be if it rose to a constitutional level because in Colorado, even back in 1986, victims' rights were pretty strong. So you want to be looking at what are the arguments? If you're briefing this, what are the section headings of your motions to quash? If you're making the oral argument to a trial court, what are your arguments? You want to start with the constitutional level are always, right? Defendant doesn't have a constitutional right here. Lo and behold, victims do have a constitutional right to privacy that is going to be implicated. Cite it. Hopefully it'll attach, but make sure you cite it to preserve it no matter what. Then go through state rules and common laws, both with regard to the victim's right to privacy and confidentiality and privilege, and the scope of what defendant is entitled to, right? Look carefully at what they are entitled to because it is actually pretty narrow. Then go through relevancy, probative value, bearing on credibility and material issues, get to the inflammatory, right, the probative versus prejudice aspect of this. You literally should have in your pocket, either in the written motion practice or in the oral motion practice, answers to each of these things. And most often, if it is discovery from a non-party, so someone that isn't the state or under the control of the state, you should prevail on these on behalf of the victim. And this is exactly when you should be getting a victim's attorney to help too, because they can do some different things. With regard to on your screen, this slide and the next one, I just wanted to flag, please, please, please be citing your victim's rights provisions, right? They have not been sufficiently litigated in this country, so you will not have a lot of appellate law. But we have, this is the federal one that was passed in 2004, and NCBLI has successfully used the right to be reasonably protected and the right to be treated with fairness, dignity, and respect for their privacy to oppose subpoenas, because the fairness and respect, it recognizes the pre-existence of the right to privacy, so we have used that. Each state, almost every state now, has constitutional or statutory provisions. California's is the one that is on the screen in front of you. It was passed in 2008. It is an incredibly dense but useful provision, and it has an explicit right to refuse an interview, deposition, or discovery request of the defendant. This is a state constitutional right of the victim to do this. And so they should win, right? In the straight hierarchy of law, they should win. So when you are crafting your arguments, make sure that you are crafting them to include all the standard stuff as well as victims' rights provisions that have passed recently. And Vicki, you were going to cover Rape Shield.
We also, and we'll cover this really quickly because we can do an entire webinar just on Rape Shield. But of course, when we're talking about privacy, we're going to talk about Rape Shield. And generally speaking, evidence of specific instances of the victim's past sexual conduct, opinion evidence of the victim's past sexual conduct, and reputation evidence of the victim's past sexual conduct are not admissible in prosecutions. And these laws are designed to protect sexual assault victims from fishing expeditions, and the exceptions to Rape Shield are usually very specific and well drawn out in the case law. Sources of injury, semen, or other physical evidence, evidence of the victim's past sexual conduct with the defendant where consent of the victim is at issue. And the defense has very specific burdens, including the time prior to trial by which these motions to pierce have to be filed.
So to wrap up this section, 2 slides, and they each focus on, so what do you do if you lose in the moment, right? Can you do anything? Can the victim do anything? And the answer is actually yes in most places. You can do something. So what you have in front of you is the Pennsylvania Code that talks about interlocutory appeals as of right. You want to know what you can do. Do you have an interlocutory appeal? Do you have do you have another device, either a writ of certiorari, mandamus, or prohibition, all of which are active tools in most jurisdictions? And also what I will say is you have some tools, the victim has other tools, right? If the victim is working with you and you're exercising their rights on their behalf, and you cite victims' rights provisions, you've just added to your tool belt additional appellate tools. So for instance, under the Federal Crime Victims' Rights Act, if you cited the victim's rights to protection and to be treated with dignity, fairness, and respect in a federal case, or if you were working in a state case and cited the equivalence, you have appellate devices different and apart from ones that you're used to. In the federal system, you have a mandatory right to appeal. The Court of Appeals must rule on your victim's rights issue within 72 hours of you seeking a writ. They have to take it. It's mandatory. So if you cite that in a federal case, you've guaranteed yourself another appellate moment. In state ones, it depends. In Oregon, if you cite the victim's rights provision and follow a particular process, you jump over the Court of Appeals and get mandatory review in our Oregon Supreme Court. So do not leave on the table victims' rights provisions because they open up additional remedies, appellate remedies, interlocutory. And then I just have this on here because, and I thank AEquitas for including it, please, please, please don't think that once it's out there that your fight is over. For instance, we just won a victory in collaboration with some prosecutors in Wisconsin and a victim's attorney in in Wisconsin to get an appellate court to issue a redacted opinion, taking out a whole bunch of stuff and then sealing those documents. It was an appellate court decision. So there's a ton we can do, and NCVLI can help you with these. And I'll turn it back over to Vicki.
Thank you, Meg. Yeah, and we regularly send jurisdictions that are facing these issues to NCVLI and Meg for help. So in wrapping up the webinar, we just want to sort of take it to how to prepare in terms of pretrial and trial. And, essentially, we talked earlier about the importance of always having open communication and explaining the process and what's going to happen going forward with the victim. So if these or portions of the records are going to come in, the victim has to be prepared. And the limitations what is admissible and what's not have to be clearly explained to the victim. So she doesn't think that everything is coming in, or she doesn't take the stand and end up testifying to things because she thinks that they're coming in that were ruled inadmissible. So everything should be clearly explained. This also has to be explained to the treating professional. If this professional is then going to be called into court to testify, that professional may be familiar with the criminal justice system, but likely will not have testified a whole lot in criminal prosecution. So the parameters of the testimony also have to be explained very, very clearly. As far as medical evidence, those of us who are prosecuting violence against women cases regularly work with the treating professionals to come in as fact witnesses, and many of them are also then going to be qualified as experts, but we want to make sure that any statements contained in those records that may have detailed a victim's prior sexual history that are ruled inadmissible, so they've been redacted, they're ruled inadmissible, are not inadvertently disclosed by a fact witness. So again, prosecutors have a duty to explain these things to our witnesses. As far as expert testimony, when we're talking about sexual assault or other violence against women prosecutions, the following experts can be called on a variety of topics, and it's important to note that the victim behavior expert is going to be an objective expert. That person will not have interviewed or met the victim, will not be testifying specifically about the facts of the case, but will be testifying objectively, providing information about victim behavior that is based on that professional expert's experience, background, education, training, etc. The mental health and cognitive abilities expert might come in, for example, if we are prosecuting a case involving a victim who has a cognitive or intellectual or developmental disability, and that testimony may be relevant for certain aspects, but not others. The toxicologist could be called in an alcohol-facilitated sexual assault case, and in that case, that expert will be talking about the impact of alcohol and or drugs on the system and the victim's processing and behaviors. And finally, that medical expert, as we said, might come in to testify as to the facts and also be qualified as an expert. There are privacy considerations that should be addressed in trial prep with all of those professionals, and that's another example of things that we can help you with. So in conclusion, we encourage you to be proactive in protecting victim privacy, and when these issues arise, reach out to other agencies within your state and nationally for help. Try to prevent the in-camera hearing when it's appropriate, when it's consistent with the interests of justice, and when such a hearing does occur, clearly understand what the standards for admissible information contained in those records are, so you can be prepared to immediately process whatever the judge's ruling is, so you can have an immediate response. You're not going to go back and scramble, oh, what do I do now? Consider the possibility of an interlocutory appeal and what impact that appeal would have on the length of the trial delay and the victim. In some cases, you'll collectively determine that's appropriate, and others you won't. The victim should be consulted, and when it comes to trial, ensure only that those statements that the judge ruled are admissible are in fact coming in, and that the testifying treating professional understands the parameter of the testimony. And whenever possible, judicial education should be attempted. If you have any questions, we encourage you not only to contact us at AEquitas, but certainly to contact Meg at NCVLI. Meg's contact information is on this slide. My contact information is on the last slide. And Emily, I will turn it over to you. Thank you for joining us.
Yes, thank you, Vicki and Meg, for presenting. As we said at the beginning, I will be sending out the presentation, the PDF of the PowerPoint, so you'll have all of the contact information at your fingertips. I'll be sending that out later today. And thank you again for your attention, your participation. Remember that AEquitas is a technical assistance provider, as is NCVLI. So thanks for coming and attending today. And on behalf of AEquitas, have a good day.